Thanks for the introduction, Jason. On behalf of Nate Skeen, I am Brad Blackham. We want to thank the Trust for inviting us here today to speak with you all about a relatively new law in Utah, very new actually. We're going to be speaking about medical marijuana today. The focus of our presentation for today is really focused on just a general overview of the statute, but in particular, we're focusing on the employment law aspects of it for local governments. There are obviously a number of implications related to medical marijuana. Law enforcement obviously is a big one. We won't be speaking specifically on that today, but certainly as questions come up and as you have questions even now from different aspects of this law, we have the resources and capability clearly to review that, research it, and get back to you. So we welcome any questions that you might have. You'll have an opportunity at the end of this to get our PowerPoint presentation. You've got our contact information on that. Feel free to get a hold of either Nate or I. Nate and I are both members of the firm's employment law practice group, and that's why we're speaking on employment law matters today. You may have worked with some of our other partners on civil rights, excessive force cases, or other land use issues, other issues like that. We cover the gamut of local government entity needs, and so we have a lot of folks at our disposal, and we're happy to be of help, and we're happy to be here today. And with that brief introduction, we'll kick it off with Nate giving us a little overview of the new law.
Great, thank you. And what I'm going to do is I'm going to jump right into the history of this law, how it came to be, and what the law says and what it doesn't say, and then some pointers that we can all try to apply to our practices. To begin, what is the law? So the law began last year, as you may recall, on the ballots, there was Proposition 2. Utah voters, this proposition was it was a medical marijuana proposition. It's changed now to what we have right now, but first it started out, was passed by voters by a 53% mark. Right after that, Governor Herbert called for a special legislative session, and that was on November 30th of last year. The result of that session was the passing and signage into law of House Bill 3001, and this is known as the Utah Medical Cannabis Act. What do you want to know about this House bill? It was very long. It was over 200 pages in length. It amended several existing provisions or sections of the Utah Code, and then it enacted several others. And the primary purpose of this was to legalize doctor-approved medical cannabis for people who had certain specific medical conditions. It was not intended to legalize recreational use of marijuana. And different from that, the measure, the Proposition 2 that was on the ballot, this imposed some tighter controls on the production and distribution of cannabis for medical use. Okay, so let's go over a few of the specific sections of the Utah Code that were either amended or that were enacted. I think one that we're going to hear the most about as we move forward is Utah Code Section 2661A-201. This is the section that deals with medical cannabis patient cards. So what does this say? It says that on or before March 1st of 2020, the state's going to start issuing medical cannabis cards to qualified people. To qualify for one of these cards, there are some basic requirements, and I say basic because there are some exceptions. There are situations where more hoops are going to be, you have to jump through additional hoops if you don't qualify for these basic exceptions or requirements. The first one is that you have to be an adult, you have to be 21 years of age or older. You can still get a medical cannabis card for yourself or a child if you need one, if they're younger than 21 years of age, but that's going to require a little more work to get through. Second, you have to be a Utah resident. This is only for Utah residents. Third, you have to have a recommendation from a qualified medical provider that your use of cannabis is to treat a qualified condition. And the next slide we go over, we'll talk about what qualified conditions are, but these are the healthcare conditions that the legislator has said you can use cannabis to treat. You have to sign an acknowledgement statement, and you have to pay a fee. So overall, I think this just shows that it's not going to be too difficult, overly burdensome for someone to get a medical cannabis card when they start issuing these. And let's go over the qualifying conditions now. These are found in Section 26, Utah Code 26, Section 61A 104. The Act identified 16 different categories of qualified conditions, and there's a number of examples I've provided here: HIV, AIDS, Alzheimer's, cancer, autism, persistent pain or nausea, epilepsy. As I understand it, with the new, what do I want to say, the legislative session on the Hill right now, I think there's been some proposed legislation to add one more category into this, and I think it's for unspecified autoimmune diseases, as I understand it. I think one thing that Brad and I both want to get across is that this act, it is very new. It was put together very quickly, and so I think we should all expect that there's going to be some amendments over time, some refining of the bill, both by the legislature and by courts. And so that's something to keep an eye on for everyone. Okay. All right, one other thing I thought would be important to point out is that previously it was a crime for an individual to possess or use cannabis, but now it's no longer, an individual is not guilty of a crime for using or possessing medical cannabis, but you have to still meet some specific criteria. You have to be diagnosed with a qualified condition. You have to have a healthcare provider that believes you could benefit from the use of medical cannabis. You could also have a medical cannabis. You can have you can be a card holder. You can have the medical cannabis card, which would make it not illegal to have or to use. You have to use it or have it in an amount that complies with the Act. And we're not going to get too in detail with what the Act requires, but the Act does require or put some limitations on how much you can possess and how much you can use, and in what form you can use it in. And I think the last point to keep in mind here is that this provision does provide some exceptions, or at least it makes it so you're not guilty of a crime if you have a medical cannabis card from a different state, but you're caught using it or possessing it in the state of Utah. There are some protections as well. All right. So let's go over what we think Utah public employers should know about this new act. The first thing we think you should know, and probably the most important section that was enacted, is Utah Code 2661A 111. It provides, it discusses non-discrimination for medical cannabis. First, under the Act, use of medical cannabis must be considered the same as authorized use as other medications prescribed by a physician. And this does not constitute the use of an illegal or illicit substance or disqualify somebody from medical care. And let's go to the next part of this section. The next part says that government employers must treat an employee's use of medical cannabis in the same way they treat employee use of opioids and opiates. There's one exception, and that's for people or for positions that if you hired somebody into that position, it could jeopardize federal funding for that employee's position. I think this is going to end up being the most important piece of guidance you'll get today. Basically, and by the way, this guidance is only for government employees. The same guidance is not provided for private employers. Essentially, what we need to be asking ourselves is, if we have a situation where an employee is using or has been prescribed medical marijuana, or test positive for medical marijuana, we need to be asking ourselves, what would we do if the same employee had tested positive for opioid or opiate use? And so on the one hand, private employers may have some more wiggle room than government employers do regarding the application of this act. But on the flip side, we at least know what we need to do and what we should not be doing. Okay, so let's get into some other provisions of the act that were amended or enacted that I think are important for employers to know. First, workers' compensation. So the first thing to know is that employers and insurers are not required to pay for or reimburse employees for medical cannabis use. And that's under Section 34A2-418. Now, another provision of the new Act, 2661A112, provides that employers don't have to provide insurance or pay or reimburse employees for medical cannabis use. So in other words, we're saying basically that an individual or employee can get a medical cannabis card. They can be allowed to use or possess medical cannabis, but we're not requiring employers or insurers to pay for that use. Retirement benefits is also an important thing to keep in mind. The statute, the Utah State Retirement and Insurance Act, has been amended now, so an employment-related offense will not include any federal offense for conduct that is otherwise lawful under the Utah Medical Cannabis Act. So what does this mean? Well, as many of you know, on the federal level, the use and possession of marijuana is still illegal. Marijuana is still considered a controlled substance. And so it's still possible to be breaking a federal law while at the same time complying with Utah's Medical Cannabis Act. As far as retirement benefits go for state employees or government employees, we're not going to hold that against you if you get convicted or charged with a federal offense, but that offense would not be unlawful under the Utah Medical Cannabis Act. Okay, let's talk about controlled substances and alcohol use. So, and by the way, this is under the statute I'm talking about now is under the Utah State Personnel Management Act. It probably doesn't apply to many or anybody here in this audience today, but it's interesting, I think, still to keep in mind that before, state employees were prohibited from manufacturing, possessing, using, distributing, or being under the influence of a controlled substance during work hours or on state property, except where it's legally permissible. That section has now been amended to specifically identify an exception for people who are using medical cannabis or possessing medical cannabis as long as they're complying with that section of the code. Okay, this is interesting for law enforcement. Traffic code has been amended. So before, it was illegal to drive with any measurable controlled substance in the body. There's now an affirmative defense for people who are driving with cannabis in their bodies, in their systems, to say that it was that the cannabis was in their system because they were complying with the Medical Cannabis Act. So in other words, they need to be qualified to have medical marijuana, and they have to be using it in a medicinal dosage that complies with the Act. All right, so let's go over a few things that we don't know about the Act. Like I said, it was put together pretty quickly, especially for private employers. There's not a whole lot of guidance. At least public employers know that they need to treat this the same as they would treat somebody using opiates or opioids. So the first thing, I think I kind of alluded to this before, is how will the federal government react to this? What are they going to do? So marijuana use, production, distribution, and transportation remains unlawful on the federal level. During the Obama administration, about 5 or 6 years ago, that administration said that they are not going to enforce these laws anymore as they apply to cannabis for medical treatment. I think it also applied for some level of recreational use as well. A lot of it dealt with the amount that somebody had or was using or possessing. The Trump administration has since gone the other way on this approach and said that they're not going to follow that the same approach that the Obama administration did. However, the Department of Justice is now really, they've allowed the individual U.S. attorneys from each state to decide how they're going to enforce marijuana laws in their districts. Last month, actually it was in December, there was an interview with our U.S. attorney here in Utah, and there wasn't a whole lot of guidance given. He basically said, I have the power to do what I think I need to do, but I'm struggling to know what that is. And so we still don't know what the federal government's going to do, especially as it applies to the state of Utah. But just keep in mind that Utah's law is a little bit in conflict with federal laws. Okay. I already mentioned this, but private employers really don't have a whole lot of guidance about what they can and can't do or how they should be reacting to an employee who may test positive to using medical marijuana or who uses medical marijuana while at work. Okay, so there's a few things that the Act does not specifically say, and we put this list together because other states actually, at some level, do provide this kind of guidance in their medical or recreational marijuana use laws. First, the Act does not say whether an employer may take disciplinary measures against employees who test positive for using medical marijuana. It doesn't say anything about whether employers may still test for medical marijuana, and whether they may ask employees who do test positive for medical marijuana to demonstrate that they are complying with the Act, that they have a qualifying condition, that they have a medical provider who has told them that it would benefit them or in their condition. It doesn't say anything about whether employers need to accommodate the use or possession of medical marijuana in the workplace or at home during non-work hours. One thing to keep in mind here is that we do know that under the ADA, because it's a federal statute, medical marijuana use is not allowed. It's not lawful. And so there wouldn't really be any protections under the ADA. Could there be protections under the FMLA? The same thing. It's a federal law. But if somebody has a qualifying condition under Utah's Medical Marijuana Act, they're probably going to have a basis to request FMLA if they want to request it or if they need it. But we really don't have much guidance, any guidance really from the Act, the new Act, about how to respond in these situations. And so we do have some unknowns. Okay, so we put together a few of examples that we think that a lot of you are going to face in the coming years. And I want to preface this by saying every situation is going to be different. And everybody here, use your legal counsel, use your city attorneys, use your outside counsel when you need to do so, when you have a situation when you're not clear about what to do. But the first example we have is what happens if pre-employment screening yields a positive medical marijuana test. We have this guidance we already gone over the guidance we have, which is you need to treat it as though it was a positive test for opiates or opioids. And so, in other words, if you have an employee, a pre-employment screen that comes up positive for opiates or opioids, what do you do in that situation? What else you can do is probably take steps to ensure that the person who tested positive is actually complying with the Act. And so can you ask your employee if they have a qualifying condition? I think that is probably fair. Now, it's usually better it's preferable if they go through the testing agency and provide that information to them. But if it's in your laps, do you have the right to do so? Again, ask your counsel, but in most situations, we probably think it's fair for an employer to say, do you have a qualifying condition under the Medical Marijuana Act? Second, you can probably also ask whether they have a qualified medical provider who has recommended it or believe it's helpful. Now, this gets a little gray because how much can you request? Can you request medical records, a doctor's note? What can you do? Can you contact their medical provider directly? There are going to be limitations on that, and so this is where you do need to be a little bit careful. Now, last, which would probably make it a lot easier is if you can just ask the employee, do you have a medical cannabis card? And once they are issued, if they do have a card, that's going to be a lot easier for you to determine whether this employee still may be hired. The last point on here is to tread lightly. The national trend is that most courts and most jurisdictions are friendly now to medical marijuana use. Some are even, a lot are friendly towards recreational use. And so you need to be careful because if there is a basis to bring a suit, a discrimination suit, by the time it does get to a jury, we're expecting that Utah juries are going to be very friendly and very liberal on the issue of medical cannabis. Okay, example number 2. What happens if you have an employee who appears impaired at work and you're able to do a drug test and they test positive for THC? The guidance we have here is that the Act does not immunize individuals from the consequences of impairment or intoxication. Now, that's, of course, different from using it in a medical form and just being, I guess being under the influence is different from having it in your system and feeling some effects from it. And so, again, fall back on the guidance we gave earlier and that's given in the Act, which is respond how you would respond to an employee who is impaired at work due to opioid or opiate use. You probably have more protections in that situation if they are impaired or intoxicated. Okay, last, let's say you have an individual with a qualifying condition who applies for and who has a recommendation or authorization from a physician to use medical marijuana. And that individual applies for a job that requires operation of motor vehicles or other machinery. I think the easiest thing to do, or the first thing you should do, is look to see whether there's any federal regulation on that point. Does the employee need a CDL? If an employee needs a CDL, that's still governed by the DOT, a federal department, and that department will require some testing, and the testing will not, and the medical marijuana use on that level will not be permitted. Are you subject to the Drug-Free Workplace Act? It's another federal act you can look under. But that's the first thing you should do. Is there anything on the federal level that would disqualify this employee, even if they would be authorized to use medical marijuana in the state of Utah? Okay, second, which I think I mentioned earlier, could the hiring of this employee impact federal funding for the position of that person? There's no protection in that situation. And last, back to what we've said before, it's just consider what you would do for an employee with opioid and opiate prescriptions. Would they be qualified for that same position? If that's the case, then you probably can't discriminate on the basis that they're going to use medical marijuana. Okay, so I think that's all for my. Oh, last thing, I just want to bring up a couple of parting points before I turn the time over to Brad to keep talking. First, what you should do right now is probably start training your HR employees to know what the Act says and what it doesn't say. They should know what to do, how to respond to these situations, and there's going to be quite a few of them, I bet, in the next couple of years. Adjust your hiring, training, and disciplinary policies and practices as necessary. Make sure you're watching to see what happens with the legislature, what happens in the courts, because you're going to get more guidance as time goes on. And then work with your inside and your outside counsel, because they're going to be able to provide some probably pretty good advice on what to do moving forward. Okay, Brett?
Thanks, Nate. I wanted to cover a couple of related issues that will come up with the new medical marijuana bill, one of which is drug and alcohol testing. There are statutory provisions that those of you who are involved in this arena are well aware of that impose certain requirements with regard to testing. And I wanted to just review a couple of things that will apply not only to medical marijuana, but to testing generally. First of all, it's clear that the statute does not preclude testing for medical cannabis, cannabis generally. You can still test for it, regardless of whether it's legal or not. You can test for it. There's a couple of issues to note. One of the challenges with marijuana is a positive test for THC, which is the active ingredient, if you will, in marijuana, does not necessarily equate to impairment or even recent use. Marijuana stays in the system for a long time, anywhere from 3 to 30 plus days, depending upon if you're an acute user or a chronic user. Obviously, chronic users will have it in their system for much longer. So making that differentiation between a positive test and impairment is going to become more challenging, I believe, unlike an alcohol, blood alcohol test, where it's much more readily apparent whether there's an impairment issue or not. Related, testing is not going to be able to differentiate between medicinal use and recreational use. It's just going to show a positive. And so that's where you're going to have to engage. If you see a positive hit on an employee, you're going to have to engage in an interactive process with that employee to ferret out what the circumstances are relating to their use. One other thing to note, and this is more of a nationwide trend, and particularly with private employers, not so much public employers, but given the tight labor market that we're in, there's a growing trend of employers eliminating testing for marijuana altogether. There seems to be some begrudging recognition by employers that there's certain things they're just going to have to overlook to be able to get qualified employees in the door. And marijuana seems to be one of those that more and more employers are saying, we're not going to test for it. We just are going to almost turn a blind eye to it in a way. Again, that's kind of a nationwide trend, something to keep an eye on. Let's review just some basics as to when testing is allowed. And this applies not only to marijuana, but any other drug and alcohol testing. Obviously, you can test for pre-employment screening, but it's important to note when you can test. Before an employment offer is made, no testing is allowed. Once a conditional offer of employment is made, then you can require an employment screening test. One question that comes up is, well, what if you have a current employee who's applying for a new position? Are they considered a new applicant, or are they considered a current employee? The best advice with regard to those folks is treat them just as you would a new applicant. In other words, you can't impose testing requirements until after a conditional employment offer is made. You can also obviously test employees under certain circumstances, all of which are defined by the statute. We're not going to take the time to really delve into what these definitions are, but you see there in the PowerPoint presentation, citation to the statute. Take a look at that if you have any questions. It details the definitions of what reasonable suspicion is, or a periodic testing, or rehabilitation testing. All of those terms are defined and likely are all included in your individual drug and alcohol policies as well. So you can test employees under certain circumstances listed there. Now, the question comes up, what do we do if we get a positive test? And in this instance, we're talking about a THC flag. The testing statute requires that there be both a screening test and a confirmation test. The screening test is obviously run first, and it's subject to certain threshold levels, and then the confirmation test is run secondarily, and it's subject to different threshold levels. And so the lab will automatically do that. The statute also requires that there be split specimens. The first specimen is done for the employer's testing. The donor, in this instance, an example would be a potential employee or an employee. If the test results are positive, they have to be notified of that result. And they have to be given notification that they have the right under the statute to request testing of the second specimen. And they must be given at least 72 hours to make that request. And if they do, the expense for the testing is divided equally between the employer and the donor. Also, if you do have a positive test, I want to refresh you back to something that Nate just reviewed, and that is proceed as advised in slide number 19. All of these PowerPoint slides are numbered in the bottom left-hand corner. Slide 19 was one of the examples that Nate reviewed about what do you do, or what should you do if you get an employee who's testing positive for THC. So go back and read that slide. Good advice there. Let's transition to some conversation about what's going on nationally with regard to marijuana laws. This is an interesting graphical map that kind of, I think, really in a snapshot gives us an understanding of what's going on. The states shaded in green are those that have allowed and passed medical marijuana bills, and those shaded in blue are those that allow both medical and recreational marijuana. There is did I skip one there? Nope. We'll come back to some more information about the states. There is definitely a changing public opinion about marijuana use generally. A 2018 Pew Research Center survey reflected that 62% of Americans favor legalization of marijuana to one degree or another, and contrast that to 2000, just 31% favored. Surprisingly, at least to me, was that there's pretty strong support across generations, with one notable exception. A majority currently of the millennials, Gen Xers, and baby boomers all favor legalization of marijuana to some degree or another. 31% of the silent generation, that was a new term for me, by the way, those born between 1928 and 1945 favor legalization. So you're not at a majority with that group, and that probably doesn't come as much of a surprise. But it is a little bit of a surprise that even amongst the baby boomers, a majority of them now favor legalization. We now have 33 states that have legalized medical marijuana use, and 10 states, as well as the District of Columbia, that have legalized recreational use. You can see the states that have legalized recreational use there. The timeline of this is pretty interesting, and I think it kind of encapsulates how quickly things have progressed. In 1996, California was the first state to legalize medical cannabis, and you flash forward to 2016, so 20 years later, a majority of states have now legalized medical cannabis. In 2012, Colorado and Washington kind of broke ground by being the first states to legalize recreational use. That was obviously in the news quite a bit. And look where we are, 2019, just 7 years later, and we've already got 10 states plus the District of Columbia that have legalized it. So there's definitely growing momentum. I mean, the fact that Utah has passed a medical marijuana bill, I think, is really evident that this is a locomotive that's picking up steam. It's not going away. Let's talk about employment discrimination protections, what other states have done, and kind of compare and contrast with what we're doing here in Utah, at least so far. From a state law perspective, we have no states that are expressly providing protections for recreational use, but 14 states are providing some express employment protections for medical use. And I would dare say all of the recent states that have passed statutes are including that, including Utah, as Nate just reviewed with us. From a federal standpoint, the Americans with Disabilities Act is the primary statute that provides employment discrimination. And as Nate discussed, and we won't review in great detail, the ADA does not provide any employment protections for the use of cannabis in and of itself. Now, one thing to keep in mind, especially when it comes to medical cannabis use, the people that are using that and have cards have underlying conditions. Those underlying conditions for which the medical cannabis is being used likely do qualify for protection under the ADA. And so once you get confirmed use of medical cannabis through testing or disclosure by an employee, it really does require further individualized assessment to make sure that you're complying with any of the accommodation requirements of the ADA. But use in and of itself of medical marijuana does not trigger any protections. I apologize for this slide and the next one. I wanted to review just briefly a couple of cases that give us some sense as to where the courts are going. This violates every rule of a PowerPoint presentation slide. It's jam-packed with information. I don't even want you to attempt to try to read it all. I wanted to include it, though, so that if you do get a written copy of this presentation afterwards, you have it and you can study it. The most recent case dealing with marijuana use came out of a federal court, which is significant because you think federal courts with the federal law the way it is would be much more antagonistic towards medical marijuana use and marijuana use in general. But this court just in 2018 has upheld the Connecticut law that provides protections to employees. And that law precludes employers from refusing to hire an employee based solely on the status of their use of medical marijuana. In this case, the employee applied for a job, or it wasn't an employee yet, an applicant applied for a job, and as part of the pre-employment drug testing, tested positive for marijuana use, and it comes out that this patient was using medical cannabis legally for pain, I think resulting from a car accident. The employer relied on the exception to the statute for requirements of federal law and refused to hire this applicant. And the court ultimately disagreed with the employer's reliance on federal law and specifically said that the Federal Drug-Free Workplace Act did not require that offer to be rescinded, and specifically mentioned that that law requires good faith efforts to maintain a drug-free workplace, but does not require testing or termination of employment for legal use. Also rejected reliance on the ADA as a basis for rescinding the offer, stating that while the ADA does not protect individual current use of illegal drugs, it does not preclude states from defining their own laws protecting employment. Another case out of Massachusetts, this is a state court case, Supreme Court of Massachusetts. We won't review this one in detail. I want to save some time for any questions, but a similar ruling. The very bottom there I thought was an interesting comment from the court and kind of encapsulates where the courts are going and frankly the public at large. The employer in that case was again relying on federal law making use of marijuana illegal, and the court ruled that the fact that marijuana is illegal under federal law does not make it per se unreasonable as an accommodation. To do so out of respect for federal law would not be respectful to the recognition of Massachusetts voters and a majority of other states that marijuana has an accepted medical use. This is a real change. The early case law and even the state of Colorado, which was the first state to pass recreational use of marijuana, their Supreme Court has been very employer friendly and relying on federal law in upholding employers' termination of employee or refusal to hire employees based on medical marijuana use. And so I think what we're seeing here is a real shift in the way the courts are analyzing this and much less inclination to rely on federal law. Just real briefly, there is no employment law protection if it's not expressly included in the statute. So the courts haven't been willing to read in to statutes employment law protections if they're not there. Obviously, that doesn't apply here in Utah for public employers. By way of just quick summary, I think it's important to note for you folks that cases are now being decided by the courts are increasingly employee friendly. Public perception is changing rapidly. And I think it's important also to note we all come to this discussion with personal views on marijuana use that are going to vary significantly based on our personal circumstances. It's important now that we have a bill passed in Utah to check whatever personal views and biases we have at the door and follow the law. And I think when it comes to employment decisions in particular, it's important to tread lightly and seek legal counsel if in doubt about what you should do.
All right. Very awesome presentation. I was feeling really good until you got to the case law.
It is a little bit scary. It's shocking how much of a change there really has been.
Yeah, I was feeling, well, we just treat this as if it's an opioid, the way we've done in the past. It's a little nebulous on showing that without the cards being in place. However, that case law definitely kind of clouds the issue a little bit. I want to turn the time for some questions here, folks. If you have questions, type those in the chat box or the Q&A box, and we'll take a few minutes and answer those questions. While we're waiting for those questions to come in, what would you say would be an action that viewers could do today? What would be the thing that they could do to start addressing this new law today?
I think the first thing that everybody needs to do is talk to their HR people. Make sure their HR people know about the act. They have even if they don't know exactly what to do in every situation, they know that when a situation does arise, they need to be huddling with everybody else from your cities, your counties, wherever you are, to make sure you're making the right decision moving forward on somebody. It's no longer the case that somebody who tests positive for marijuana can't be employed with you, needs to be fired, should be arrested. And so, in fact, as we've gone over, I think it's probably the other way around. It's more of an exception nowadays that those are cases.
The other thing I would just mention is review your policies and procedures and make sure that they are in compliance with the new law. And then the third thing I would mention is keep an eye on this. I expect, because this statute is so new, that we're going to see some additional changes. And so keep an eye on what the legislature is doing. It's evolving, and I think that we're going to see some additional changes to it as we go along.
Yeah, for sure. I think that's great guidance. We have a couple of questions, and they kind of go down the same road. One is, what about DOT drivers? The other is, any guidance or thoughts about law enforcement and/or firefighters who want to use medical marijuana? So safety-sensitive type positions,
Right.
or DOT drivers that have that federal guidance.
Well, I'll answer the first one. I'll make Brad answer the second one because it's harder. The first one I think is fairly easy. The DOT is in charge. There's federal testing requirements. Medical marijuana in any form is still illegal on the DOT level, and so if somebody needs a CDL, they're not going to be able to pass the medical examination, as I understand it, if they are using medical cannabis. If it's been prescribed, if they test positive, that is my understanding. So that's a little easier. Now, we did, joking aside, we did talk yesterday about what about police officers, what about firefighters, what about people who are in situations where, you kind of may think a little hard about, well, do I want somebody in this position using medical marijuana even, because it is a drug that can intoxicate somebody. And I think the takeaway that we had was, first, of course, opiates can intoxicate as well. What is your policy on that? Second, though, I mean, if it's an employee carrying a gun, if it's an employee going to the top of a telephone pole or an electric pole, there may be some different situations, maybe some different considerations to take into account. And so every situation is different, but I think you're going to have, I said a minute ago that the exception nowadays is probably not hiring somebody if they're using medical marijuana. Those are where you get a little closer to the line of whether or not you can refuse to hire them, or if there's a different position they could be in. So, what do you think, Brad? Anything to add on that?
Yeah, I would just say that remember the normal ADA interactive process. If you have, whether it's a police officer, firefighter, or a front office assistant who is using marijuana, I think that you need to go through that interactive process. Find out what medical conditions they have, what accommodations they need to be able to perform their job, and whether they can use other accommodations. And then I also think you have to engage in an analysis of whether their use of medical marijuana is jeopardizing the public, whether it's impairing them from being able to do the essential functions of their job. You're not required to accommodate someone who cannot perform the essential functions of their job. And obviously, if you're a police officer or firefighter, that's going to be very different in terms of what those essential functions are. But again, I think the key with all of that is you need to engage in that process just like you would with any other qualifying condition under the ADA, and get to the bottom of what the impairment is, what accommodation can be made, and whether they can do the essential functions with accommodation.
Great, good guidance.
So I might also kind of add a question onto that. Often what we might see with an employee where there's some question about whether a medication they're using is acceptable given the work that they're doing. Sometimes an employer may use a fitness for duty evaluation where they get a medical doctor involved in the process. And I assume that the same thing may apply with medical cannabis, where you would have a good detailed job description, what the employee needs to be able to do, what their functions are, and if there's any question about whether their dosage is beyond what would be safe for the job that they're doing, would you use a fitness for duty kind of evaluation?
I think so.
Absolutely.
Yeah, it's a great idea.
Absolutely, that's a great idea.
Yeah.
Okay.
I mean, the people in the best position to figure out if somebody can perform their job is probably a doctor, right? So I think that's right.
All right. We have another question. This one might be a lot easier. What if an employee goes to somewhere where marijuana is legal for recreational use, comes back to Utah and tests positive? What could or could not happen?
Yeah, so that's we look into that a little bit. That's not kind of the focus of our presentation today. I guess I'm thinking more of it on a criminal side. But from what I understand, the Act does not provide any protection for recreation use wherever, here or outside of the state of Utah. If you go back to the early slides of the presentation, there's the exception that says you have to use marijuana or have any marijuana in the state of Utah. It's got to be in compliance with the Act, and that applies to people who are using outside and then come back in the state. Same thing applies. So if they're using it outside and they don't have the card or the a qualifying condition, then there's not really any protections that I see under the Act.
The tricky part with that is, how do you know? They'll test positive, and the testing is not going to be able to differentiate between recreational use and medical use. And so that's where, discussion with the employee is going to come in. And with the first question you're going to ask is, do you have a medical marijuana card?
Yeah.
And if the answer to that question is no, then it becomes a pretty easy decision to make.
Let me add one more thing to that. So I don't know when they're going to start issuing the cards. I heard that maybe they have already started. I think there is some protection until
That's right.
January of 2021, actually.
That's right.
So it's going to get a lot easier, I think, once we get to the part where you have to have a card. But for now, you may be going off of somebody saying they have a qualifying condition and then getting proof from their doctor that it's something that's been recommended to them.
Yeah, good catch, Nate.
Yeah, great. Well, it looks like that's all the questions that we've had come in. I think this has been a great presentation and a great discussion today. And like you've mentioned, more to come. And this is definitely not a closed case, and everything is where we're going to be. But this is kind of the start of the discussion. And so we really appreciate Brad and Nate's taking the time to help us get going on this. So take some action today, have the discussion in your workplace, and especially, as they say, with HR professionals. So we're all on the same page when it comes to how we're going to address this, and then keep your ear to the ground as things change. There very well could be some changes in this legislative session as well. Okay, final word. Anything else that popped into your head?
No, I just say, again, thank you for inviting us. We will be keeping our eye on this, and as changes come up, we'll be happy to update you and try to keep you abreast of this as it goes along, because it does feel like it's going to be a dynamic process.
Yeah, for sure. Thank you so much once again for presenting. We have recorded the session, and we'll place it up on our website as soon as IT gets it there. And so feel free to share that with your management or others who are interested in this subject, and definitely if you have questions and comments, I think this is something that we've got to work through together and learn together. So thanks once again. Appreciate everybody's attendance on a snowy day, and be safe out there.
Thank you.
Thank you.